Today's video is force measure under UAE civil codes, especially in construction projects. So, statutory foundation under UAE. Force measure in the UAE is a statutory doctrine under the UAE Civil Transition Law, Federal Law number 5 of 1985. So, what are the key provisions that are governing the force measure in different aspects of Article 273, which deals with the termination due to impossibility. Article 287, exclusion of liability. Article 249, hardships, that is under exceptional circumstances. Article 893, 894, construction specific contracts. These provisions operates even in the absence of a contractual force measure clause, although the contractual wording typically provides where drafted. So, what are the core legal principles that defines impossibility under the Article 273? The legal threshold is under 273. Force measure applies only when the performance becomes unforeseeable, unavoidable, objectively impossible, not merely difficult or expensive. So, this is a high evidentiary threshold consistently applied across the UAE courts. The commercial impracticability, cost escalation, or just delay does not qualify as force measures. What are the consequences under Article 273? Total impossibility, that is, the contract is automatically terminated. So, obligations cease entirely. Parties revert to pre-contractual positions. Next is partial impossibility. Only the affected parts is extinguished. Remaining obligations continue as it is. The counterparty may elect termination. The third one is temporary impossibility. Performance is suspended. Possible termination in continuing contracts. This differs materially from fatigue, where force measure clause, that may be 1980, depends on the color in the year, generally leads to suspension first and termination later. Article 287. It is a shield against liability, that is the damages. Even where termination is not pursued, Article 287 provides a defense mechanism against damages. No liability if harm arises from force majeure, external causes, third-party acts, natural events. It provided the party has no control and no fault. Practical implications in the construction are that the contractor may avoid liquidated damages, delay damages. Employer may avoid claims for non-availability of site if force majeure is. Construction specific frameworks. Mukawala contracts. Under UAE law, the construction contracts are classified as Mukawala contracts with additional provisions, especially in Article 893, 894. There are other articles also dealing with construction contracts. Article 893, either party may request termination if performance becomes impossible. Article 894, the contractor is entitled to the value of the executed works, which is already executed, recoverable expenses to the extent of the benefit to the employer. So what is the strategic impact? This is critical in EPC scenarios. Even if the contract is terminated due to force majeure, contractor retains the entitlement for the executed works and the costs incurred. So what is the distinction between a force majeure and a hardship, especially under the clause Article 247, 249. So what is the threshold? The threshold of force majeure is very high, that it has to prove impossibility, either partial or temporary, as we discussed. Hardship is severe difficulty. So outcome of a force majeure can be a termination or discharge from the entire contract. Hardship is a judicial adjustment. For example, the war blocking the site accesses, that comes under force majeure. 300% material price increase, which is price increases are usually considered under contracts when the risk is transferred, but 300% is abnormal and it cannot be accommodated. That becomes a hardship. Under Article 249, courts or arbitrators may rebalance the obligations. They may reduce scopes, reduce the prices, or extend time. Practical insight is most force majeure claims in construction should actually be pleaded under the hardships, not under the Article 273. Application in the construction projects. 6.1. A typical force majeure event in UAE projects. The recognized force majeure events are war or regional conflicts, government embargo or shutdowns, pandemic-related site closures, extreme natural events which are out of control of the parties. The courts have accepted wars as force majeure in many of the recent rulings. Events commonly rejected. For example, what are the events that are commonly rejected under UAE civil code by the courts or the arbitrators? Or the labor shortages, supply chain delays, price escalations, subcontractor failures. Unless they lead to absolute impossibility, they do not meet Article 270. So, interaction with the EPC or FIDI contracts. Contracts versus statute. If the contract includes the force majeure clause, the contract prevails. If it is silent on the force majeure, the civil code automatically applies. The key conflicting areas are, for example, if threshold, the FIDIC approach is that it prevention or delay. UAE law approach is strict impossibility. The relief is under FIDIC, you get EOT for force majeure and cost very rarely for certain areas which has been directly affected by the force majeure. But UAE law, it gives termination and it avoids liability. Coming to the payment, payment is often allowed under FIDIC contracts and payment is not automatic under UAE. Continuation is encouraged to continue the business, and UAE the law doesn't use any pressure on the continuation. It is parties' autonomy whether to continue the contract or. The strategic risk is contractors just merely relying on FIDIC logic will not help. They should understand the UAE civil law to get a stricter threshold. Claim strategies for construction professionals. First, let's see about the contractors. Avoid over-reliance on the force majeure clause. So, use Article 249 hardships where possible. Establish the direct causation, which is very, very important. Absolute impossibility, no contributory fault. If there is a fault from the contractor side also, it will open up a new discussion whether the contractor had a prevention principle where his own mistakes will not make him eligible for the relief of the damages. Maintain the government notices, site closure evidences, logical disruption records. Always comply with contractual notice provisions. Time bar clauses are very important. Good faith obligations under Article 246. For employees, so you can challenge whether the performance is truly impossible, whether mitigation was attempted. Mitigation is a mandatory provision. You can shift the risk from the level of force majeure to contractual risk allegation. So preserve the right to partial performance. Termination strategy is use this if beneficial. Critical risk zones in EPC projects. From a commercial standpoint, the highest exposed areas are interfaces where multiple contractors are working in the same contract and there is no FM production. Supply chain disruptions rarely qualify as force majeure claims. Design delays, it's our internal risks, not force majeures. Government actions, mostly credible force majeure triggers. So what are the drafting recommendations? Because dealing a force majeure on the occurrence of the force majeure is different. But a good contracts professional must capture this while drafting the contractual provisions or reviewing the contractual provisions from the employer. A well-drafted force majeure clause in UAE project should define the events beyond the statutory baseline, include the delays, not just impossibility, because this is a major role in construction contracts. Provide EOT entitlements, cost recovery mechanism, suspension rights, clearly distinguish between what is force majeure and what is hardship and what is change in law. Without this, the parties fall back to the Article 273, which is commercially reasonable. Coming to the end of this presentation, what are the key takeaways for project leaders? So, UAE force majeure is statutory, strict, and termination limits. The legal test is impossibility, not difficulty. Most construction disruptions fall under hardships, not force majeure. Article 287 is often more powerful than Article 273 when it comes to the claims defense. So, contract drafting is critical to override rigid statutory consequences. Thanks for watching this video. We'll watch in the next video. Take care. Bye.